The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome to everyone. In particular, we want to welcome the students from Madrid High School. So thank you for being here with us. Today we celebrate Constitutional Day. Even though it was yesterday, we're doing it as a part of our proceedings today. Because it was in 1787, September 17th, that our country produced our Constitution. And it is indeed cause to celebrate today, 232 years later. And by the way, our Iowa Constitution, we celebrate at the same time, even though it was signed on March 5th of 1857. But I think it's important to observe before we begin these proceedings this afternoon that the commemoration of our Constitution is not just something for lawyers and judges to do, but it is for all of us to do and observe. It's a day for all of us as citizens to recognize what draws us together, and that is our Constitution, the values that it expresses, and the principles that it gives to all of us. And it identifies us as a community of people that are bound together by that doctrine, and particularly that preamble to our Constitution, which gives us our objective to become better and to become a more perfect union. So those are some of the reasons, but there are many more for us to pause and celebrate our Constitution. We have 4 cases that will be submitted this afternoon. Those cases are State of Iowa versus Juan Daniel Salcedo. Second case is Heather Young and others versus the Iowa City Community School Board and others. The third case is State of Iowa versus Larry Gross, Jr. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Tina Hassan Mohammed. Those last 2 cases are submitted now to the court without an oral argument, and we'll now hear the arguments in State versus Salcedo. Ms. Spellman.
May it please the court? Counsel. My name is Molly Spellman. I represent the appellant, Juan Salcedo, relating to our application for interlocutory appeal following the district court's denial of our motion to suppress in Johnson County. Mr. Salcedo asks this court to find that the district court erred in each of its rulings in our motion to suppress. Mr. Salcedo asks specifically that this court find, first, that the continued and prolonged detention of Mr. Salcedo in order to engage in questioning, which was unrelated to the scope of the mission of the stop and which extended the scope and the duration of the stop, was violative of Mr. Salcedo's constitutional rights under the federal Constitution and under Article 1, Section 8 of our Iowa Constitution. Secondly, Mr. Salcedo asks that this court find that his consent to search his vehicle was not knowingly and voluntarily given, and we ask that this court adopt a ZERPST, knowing and intelligent waiver standard, because law enforcement failed to advise Mr. Salcedo that he had the right to refuse to consent to search. Alternatively, should the court not choose to adopt a ZERPST analysis, we ask that this court find that Mr. Salcedo's consent to search was involuntarily given under an Iowa version of the Schneckloth with teeth analysis of the totality of the circumstances. Third, we ask that this court find that Iowa Code Section 321.297, subsection 2, is unconstitutional because it is void for vagueness and it violates Mr. Salcedo's due process rights under the federal and the state constitutions. And lastly, we ask that this court find that there was no probable cause to stop Mr. Salcedo's vehicle and that the deputy in this case operated under a mistake of law. Justices, we have raised both federal constitutional issues as it relates to search and seizure in this case. We've also raised state constitutional issues as it relates to Article 1, Section 8 in both our motion to suppress and in our application for interlocutory appeal. Specifically as it relates to the scope of the stop, we are asking that the court go through an analysis of a investigatory scope analysis under Article 1, Section 8 of the Iowa Constitution, and specifically under the consent and the request to engage in a ZERPS analysis, we're asking that the court engage in an analysis under Article 1, Section 8 of the state constitution. We understand, certainly, that the court gets to choose which constitution it chooses to analyze a case under, and we also understand that while the United States federal U.S. Constitution may not necessarily be a floor, and certainly the Iowa state constitution may not necessarily be a ceiling, we recognize that this court has historically and recently set forth its belief that Article 1, Section 8 does provide broader rights and greater rights under its
Let me just, let's say we're proceeding under the federal Constitution as in Part E. Reviewing the video here, it did strike me there is one important difference between the facts here and in Part E that I think cuts in favor of your client. In Part E, it did appear at least that there was an effort to process a traffic violation, whereas here it seemed that the deputy was just looking at the rental agreement, kind of going through the motions and asking questions. Would that violate federal constitutional standards under Rodriguez and Part E?
Yes, Justice Mansfield, I agree with what you've stated. In this case, the deputy admitted at the suppression hearing that he did nothing to further issuance of either a traffic violation or a traffic warning. He did not even enter Mr. Salcedo's information or name into the computer. And so in this case, the deputy admitted also on the record that his line of questioning during that detention, during that time he was holding on to the rental agreement and just sort of looking at it, he was engaging in that line of questioning, quote, in investigation of further criminal activity. And he was doing that because on the road he saw that it was a rental car, and so he believed there was some criminal investigation that needed to be done. But I believe this could either go under in relation to the duration under the federal constitution, and that under Rodriguez and under Part E, he did nothing to further the mission of the stop, and that the analysis would be any of that time where he's not engaging in furthering the stop would have to be taken out of the analysis. So his failure to actually do anything about the citation would be problematic.
I mean, there are two possible readings of kind of Part E and Rodriguez. One reading is sort of however long a typical stop takes, that's how long the officer gets to detain the motorist and ask questions. The other reading is the officer has to actually process the stop and ask those inquiries that the officer is allowed to make related to the stop. And during that time, as long as it doesn't prolong the stop, they're allowed to ask unrelated questions. I take it you take the second view of what Part E and Rodriguez mean, right?
Correct. Because in this case, it would be a different situation if he actually was doing something to further the traffic citation or traffic violation. Then we would have to admit that maybe he was making some small talk, or maybe he was doing some additional unrelated checks, unrelated conversation, while he was actually furthering the mission of the stop. But in this case, it's clear in the record that he did nothing to further the mission of the stop.
What does the record reflect with respect to the time when this deputy called for backup? Because when I watched the video, it wasn't clear to me when he did that. It seemed like maybe he did it before the video came on. And when did he call for a drug dog, if he did call for the drug dog?
Yes, Justice McDonald, there are two videos in this case. One is a body cam, one is a dash cam. I'm not sure if you've reviewed both of them, but the deputy in this case has made clear that he called for the second deputy once he had Salcedo detained in his patrol vehicle, which was a minute or two into the stop, and that at the suppression hearing, the transcript reads that he thinks he called for the second deputy almost right away. What we have figured out through sort of aligning the times with the police reports is that the traffic stop occurred at 9:05. The engagement of Mr. Salcedo in the patrol vehicle front seat after the pat-down occurred within a minute at 9:06. And then it was at the latest 9:09 that he radioed for assistance. And so that would have been at 3 minutes at most that he radioed for assistance. It may have been less than that, according to his testimony at the suppression hearing. And then the second deputy arrived at 9:13. So the second deputy arrived within 8 minutes from the stop. And at that time, I should make a correction to the record because I've re-listened to the body cam of this case since submitting my brief in December. And upon re-listening to the body cam, it is clear that the first officer says to the second officer, quote, "I would love a sniff on this." And I didn't include that in the brief because I didn't hear it well enough when I first reviewed the case. But he made clear to the second deputy who arrived on scene within minutes that he wanted a canine. He wanted a drug dog sniff, but he then quickly expressed disdain that he couldn't get one. And it was either because there wasn't one in the county or that deputy wasn't trained yet.
I interpreted that to mean that at some point prior, the deputy had specifically requested a canine as part of the call for backup. And I take it that's ambiguous. Maybe he was just saying when he got out, "Can I get a drug dog?" And then he says something like, "I can't believe there's no drug dog in the county," or something like that.
We don't have in the record what he transmitted through either dispatch or to his other deputy regarding maybe a personal conversation or what message he sent to the other law enforcement officer. But I think we can infer that that was it because through the conversation between the second officer and the first officer, it's clear that he knew that officer that came to the scene wasn't yet trained. He was going to be trained in being a canine officer, but he wasn't there yet, and they didn't have any more in the county.
I want to ask you, sorry, about those first few minutes you just summarized. At 9:05 was a stop, 06 he was in the car, and 09 he radioed for assistance. So in that small period of time, couldn't it be interpreted that that radio for assistance was an objective observation that perhaps he knew he needed help in this, and he had somebody in the left lane. He already knew it was a rental car. So he already had quite a few things in his mind. And I think he testified at motion to suppress that the cell phones, 3 cell phones, and the extra luggage he noticed right away. So couldn't it be that all of those steps within 3 minutes indicated he was looking into more?
Justice Christensen, I'm happy that you brought that up because I wanted to clarify for purposes of the record because I believe the Appellee's brief sort of mixes this up a little bit. The 3 cell phones, which the state uses as a factor for possibly being an indicator of drugs going on because one might be a burner phone and there were only 2 people in the vehicle. And then the presence of luggage, I'll talk about it in a second. The 3 cell phones, that factor was not observed by the officer until 13 minutes into the detention.
That when he said something out loud about it, but I thought his testimony said he noticed it right away. Isn't it possible that he didn't alert the people that he was aware of that at that moment?
And if you go through the transcript again and you go through the direct examination by the county attorney and then the cross-examination, it's clear that he didn't observe the 3 cell phones until he spoke with the passenger later on after the second deputy arrived on scene. So that presence of 3 cell phones can't come into the analysis of reasonable suspicion at the onset of the stop or the initial detention, because it's clear in the transcript that he didn't observe those 3 cell phones until he went back into the vehicle to speak with the passenger.
Okay, I want to jump beyond that to another topic. You have several things raised in your brief. One of them has to do with your request for us to answer that question that was unanswered in PALS and the cases that you use to support your position. Am I correct? And you can correct me if I'm wrong, because I'm sure you know the record better than I do at this moment. But aren't those states, haven't they limited their waiver test to not include vehicles on those cases?
To an extent, and the Appellee has spent time in his brief to go through and to discuss how those different states have limited it since PALS, and certainly the court can use those states in their weighing of what is persuasive authority. I think that things have been working in New Jersey. I think that a lot of the other states might not engage in a separate analysis under the state constitution, and so we aren't able to change what has happened in the other states. But certainly, I think some of those states, it's important to.
How many states require a ZERPS type waiver analysis for a traffic stop consent search?
Certainly, New Jersey, it has been working well there, and that state has been doing this for some time. In regard to, it's not a lot of states, and that's just the state of it.
Is New Jersey the only other one?
I went through in the brief the different states that have engaged in ZERPS, but they have been limited to some extent. Certainly, we have other states which have engaged in ZERPS, where Mississippi, Arkansas, and additionally Washington. Just so I don't forget the luggage issue, Justice Christensen, the luggage was observed by the deputy at the onset, but the additional factor of determining or discovering that the presence of luggage in the back seat comprised all of their personal belongings and that nothing was in the trunk, that fact, which the state uses to bolster its argument that there was reasonable suspicion, that factor didn't come in to the deputy's knowledge until about 13 minutes into the detention as well, when he went up and spoke with the passenger.
Speaking of 13 minutes, would you agree with me that from pullover to the end till the search, it was about 14 minutes?
Yes. Certainly. And
the basis, the original stop, they're pulled over for going 10 miles below the speed limit on Interstate 80, and you're challenging that statute as being void for vagueness, right?
Correct.
I spend a lot of time on Interstate 80, and not many people are going 10 under in the left lane for very long. What's unclear about this statute that you should move over to the right lane? Why is that void?
We're arguing that it's void for vagueness because there was no other traffic on the highway. So these were not ideal weather conditions, meaning it wasn't broad daylight, sunny, dry day. It was nighttime. It was 9 o'clock. Granted, there were no adverse weather conditions, but our argument in that regard is that the statute is so vague because it talks about a vehicle proceeding at less than the normal speed of traffic.
That'd be a good argument if it was the only car on the road. But didn't the trooper or the deputy testify that he came up behind and the guy didn't move over?
Salcedo was the only car on the road until the officer, who was going 75 miles per hour in the left lane, came upon Mr. Salcedo. And then at that time, those two vehicles comprise the flow of traffic, and they comprise the normal speed of traffic. So our argument in that regard is that this would be a different case if the deputy would have gotten over to the right lane, sped past him, and then Mr. Salcedo would have been on notice that he was going slower than the speed of traffic. In this case, the deputy came upon Mr. Salcedo, slowed down, had room between them. This is all clear in the transcript. And then he fell behind him immediately to the right in the right lane with at least 2 cars distance between them, and paced him, which means he fell in line with him. So they were the speed of traffic going at the same speed. for 3 to 4 miles. Had the deputy slammed on his brakes, honked, given him some sort of notice, gotten into the right-hand lane, and sped past him, this would be a different situation. We probably wouldn't have raised it. But in this case, when the deputy sort of calmly fell behind the car and then ran its place, decided it was a rental, or realized it was a rental, and then engaged in pacing him at the same speed, they created the flow of traffic and the normal speed of traffic. The fourth issue, which I'll just briefly touch on, is that
You may sum up your argument.
Thank you. Lastly, I want to address that there was no probable cause in this case to even pull him over in the first place because not only because he didn't fail to follow the statute, but also because the deputy had a mistake of law in this case. It was clear this statute is so unclear to a person of ordinary standing that not even the deputy had a correct understanding of the law. The deputy can be heard many times throughout the body cam that he believes Mr. Salcedo was violating the statute because he was going lower than the speed limit in the left lane, which isn't accurate. Certainly if a person went over the speed limit in the left or the right lane, that would be a violation of the traffic laws. Justices, we're asking that you decide these issues under our state constitution, that you adopt a bright line, knowing, and intelligent rule for a person who is confronted with the request to consent to search a vehicle so that they may be allowed to know their constitutional right to refuse. And we ask that the court engage in both scope and a duration analysis as it relates to the continued and illegal detention. Thank you.
Ms. Spellman, thank you as well. Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court, counsel. Good afternoon. I want to start with the record. Page 33 of the motion to suppress transcript. This is cross-examination from defense counsel of Deputy O'Hare. Do you remember what time you dispatched and called in over the radio for assistance? I don't know the exact time. It was right after we got in the squad car. If I told you it was 9:09 p.m., would you have any reason to disagree? No. What was the purpose of radioing in? It's common practice when you think you're going to further your investigation or you have problems or search a vehicle. At that point, had you decided you were going to search the vehicle? At that point, I thought there was a chance I'd be searching the vehicle. Okay, so here's where we're saying that he had reasonable suspicion, right? Here we go. At that point, what was your basis for your belief that you would be searching the vehicle? At that point, it was a rental vehicle, the 3 phones, luggage in the back seat, and it being a third-party rental. And also before that, when he made the stop, he already knew that it was a rental from California specifically traveling eastbound, but okay. And then defense counsel clarifies that they thought that he observed the cell phones and the luggage later. And he says, no, I saw the luggage and the stuff right away, but only asked about the luggage and stuff later on. I think stuff is fairly read there to be about cell phones too, considering that's what he just said.
If he had probable cause of search at that time, why did he wait 9 minutes after the other officer came to ask for a consent search and just not search before then?
Well, I think that he might not have known whether he had probable cause, and that would be a different issue. But what we are saying is that he definitely had reasonable suspicion to extend the stop and investigate further. And certainly that reasonable suspicion strengthened as soon as he asked the question about their travel plans and received the answer that he received, that they flew one way.
But then he tells the person who comes, the other officer, there's no dog in the county. He was sort of surprised, no dog. He says, well, I'll just keep engaging these people until I could get a consent search. I mean, that was his statement.
I mean, that's the hope, that avoid the issue of whether this reasonable suspicion will develop into probable cause, which it might have with additional questioning, but avoid the need to determine whether it did by getting consent for a search if possible. And I think that that's a valid investigative technique. Now, I realize the question that's coming is, what would have happened if he had not gotten consent from Salcedo and or Rodriguez to search the car? What would have been the next investigative step? And the answer is continue the investigative detention for a reasonable length of time, and that can vary based on the strength of the reasonable suspicion of drug trafficking, and see what else can be uncovered through that investigation. And if the officer believes it rises to the level of probable cause, Then the officer would decide to search, and we would have an ex post evaluation. Or if the officer wants to really dot the I's and cross the T's and thinks it's safe and feasible, they might decide that they can continue the detention to get a warrant, although there might be. Anyway, the point is that this wasn't a situation where if Salcedo had said no, the traffic stop would immediately end and he could go. And I want to clarify that the reasonable suspicion of drug trafficking started at a point before he would have had to terminate the stop based on the violation of 321-297-2. Reasonable suspicion of drug trafficking ripened right away as soon as he made that initial contact and those initial
based
observations.
on the number of phones and the fact that it's a rental car. And I guess to some extent I'm having trouble with that. It seems very common that people carry multiple phones, in particular people who are driving rental cars, right? If you go somewhere for work, you have a personal phone and a work phone. That's not uncommon. I'm not sure what's suspicious about 3 phones in a car with 2 people.
Well, the third phone, the officer testifies about a burner phone. The idea is that the burner phone is used to make contact with somebody relating to the drug trafficking in a way that doesn't create a record tying that person to the traffic, to the mule's phone in a more permanent way. That burner phone can be thrown out. There's also the luggage in the back seat. I think it's very interesting that Pardee cites to Beck, where Beck said the officer thought it was suspicious that there was no luggage in the back seat. And the court says, that's totally normal. You would expect people to use the trunk for the luggage. Well, in this case...
This branch issues 2 phones to people all the time when, as Justice McDonald said, and, I drove to the West Coast last year and back seat was full of luggage because my trunk was full of luggage. I mean...
Well, when asked what's in the trunk, he wouldn't have said nothing.
I don't have to respond to him in any way.
That's true. You don't.
But I thought the information that there was nothing in the trunk came later. You're saying by 9:09, so 4 minutes into the stop, the deputy knew that there were 3 phones and there was luggage in the back seat, which if you go down to my car right now, there is, and that there was nothing in the trunk. Is that the state's position?
And I would clarify, I didn't know that there was nothing in the trunk until he asked later. He also knew that there were California plates, which obviously we know from Pardee, not itself so significant, but a California rental car with a third person on the rental agreement who is not present. Now, this officer is like 3 days off of drug interdiction training and knows through his training and experience that this is a significant factor when you're talking about transcontinental drug trafficking, that California is a common point of entry. Rental cars are often used, my understanding is to avoid forfeiture of actual personally owned assets. And a third party is put on the rental agreement, often who is not present in the car as the drugs are being transported, right? And I'm not saying that this would hold up as proof beyond a reasonable doubt. Obviously not. What I'm saying is this is enough to raise the test is founded suspicion. This is enough to raise, and, the Arvizu analysis, none of these independently are illegal.
In Pardee, the same kind of situation where a car's going slow with a California license plate on it. But even in Pardee, there was evidence that there was a strong scent of a deodorizer that is known to mask the smell of marijuana. There was general nervousness of the defendants, and the car had this lived-in look to it, like they were driving hard without stopping. And so even under those additional circumstances, didn't this court say that there was no reasonable suspicion?
Yeah, that's true. I would distinguish Pardee based on the fact that those are all things that are common to road tripping in general. Unwanted odors in the car and a lived-in look in the car.
But the deodorizer was the kind that specifically is used to overcome the marijuana smell.
Right. That fact in Pardee actually that causes me to doubt Pardee a little bit, but even still applying it, I still say that these are qualitatively different, specifically because of the drug interdiction significance of the third-party rental agreement and the more phones than people, leading the officer to conclude that one of them was a burner phone.
To me, what I can't get around is in Pardee, the officer is at least making some effort to process the traffic violation, doing a warrant check, starting the process of writing up a warning for this individual for the violation. And here this is pure investigation. It's almost like the deputy took the position, well, I'm reading Part E, and I guess I get to have a free 10 minutes or so to do my thing. And should that really be the law?
So I don't. So first off, I think that asking where are you going, where are you coming from, I think that is permissible in the scope of investigating any traffic violation. We provided authority in our brief for that. For example, if he just came from Muscatine on a road where the speed limit is lower, might not be aware that he's going lower than the normal speed of traffic in the left lane. But regardless, to answer your question more directly, I think that if the duration of the stop is extended by this inquiry and these tactics, that is a problem under Rodriguez Party and especially Coleman. If the duration of the stop is not extended, I don't think that there's a constitutional problem because there's no additional seizure. That the questioning itself, it might go beyond the scope of what you would expect during that stop for probable cause for that traffic offense. But if it doesn't extend the duration of the stop beyond what the officer had basis for, I think that is constitutionally still permissible.
But, I mean, under that other reading of those cases, it isn't you get a certain amount of free time to do an investigation. You get to do a stop, and however long the stop takes, you can do some unrelated things.
And I think
Isn't this case problematic under that reading?
I think it becomes problematic after the questioning about where it would, if there weren't already reasonable suspicion for the drug investigation, it would become problematic after the questioning of where are you coming from, where are you going? That question serves purposes related to both investigations. And once you start asking more questions while you're not also entering the data into the computer, that's when you can start making an argument that this has unconstitutionally extended the stop in terms of its duration, because you still have to do the other things that you were going to do anyway for this 321-297 stop.
I watched the video, and I'm sure you watched the video. I didn't see anything in the video for this officer doing anything to write a ticket or a warning.
I agree.
In fact, he's looking at the rental agreement with the license on top of it and just futzing around with it. I don't think he had any intention to write a ticket after he stopped him when you look at that video.
Well, I think that by the time the officer makes it back to the car with him, he knows, and he testified about this truthfully, I think, that he knows what his investigation is, and that the importance of writing this ticket or warning is now dwarfed by the importance of conducting this investigation, which he believes he has founded suspicion for at that point. And
that's where I want to go with you, and I'm challenging, I guess, maybe a little bit. I'm a little nervous because I know the guy down at the end wrote Part E. But I'm thinking there might be a difference between this case and Part E. Am I correct in Part E that the stop had already been prolonged when they started making the observations that they were arguing reasonable suspicion? And in this case, that's why I was previously asking the other attorney to narrow it down to that period of time, 9:05 to 9:09. We're talking about 4 minutes. Isn't that different than Part E?
I agree that it's different in that regard due to that duration. The most interesting part of Part E to me is where first the conclusions reach that there's not reasonable suspicion. And then to go beyond that and say, now that we've gotten there, we need to decide if that means that we can't consider the things that are said in the discussion about travel plans. But in this case, the discussion about travel plans is within the proper scope / duration of the original stop that's supported by probable cause. So even if you disagree with me that there was reasonable suspicion, founded suspicions, and ambiguity worth investigating about whether this was drug trafficking, if you disagree that he had that by the time he returns to the car and makes the call at 9:09, I think you still consider the discussion about travel plans because that is within the permissible scope and therefore duration of the 321-297 stop. Good, 297. I keep transposing them. So I think that makes this very different from Part E, and that's beyond the factual differences that I've already described. I want to talk about the consent issue because I know that's a hot topic. I disagree. I would say that New Jersey is the only state that I'm aware of that extends this to vehicles. And I picked up on the statement that this is going well in New Jersey. We provided some empirical evidence in our brief that, empirical data from New Jersey, that even with requirements that are that New Jersey has implemented, it doesn't seem to be encouraging people to invoke their right to deny consent. That consent search rates are relatively unaffected. Now, you might look at this and say, that's a good reason to require an advisory because it doesn't seem to be hampering law enforcement. But I would look at it and say, this to me is evidence that if New Jersey, in terms of consent search rates versus refusal rates, looks like neighboring states, I look at that as meaning that people generally know that they have a right to refuse to give consent when asked by police during a stop. And even if most people don't, if you disagree with me on that, it's hard to look at what happened here and think that this search was involuntary. Mr. Salcedo gives consent in response to a statement that's not even really asking for it, and then again confirms when he's clarified, you're saying it's okay for me to search the car. That clarifying question, I think, carries with it a statement that, you're saying it's okay for me to search. The obvious implication is that if it's not okay, then I can't.
I tend to agree with you. This is not the best test case for the argument that you have to give notice to, because this individual watching the video seems very nonchalant about the whole thing. Yeah, go ahead, search it, do all you want, search away, have at it. So I agree with you on that. But let me ask you about another issue. What about this question about the constitutionality of the statute? It does seem that the officer had a very different idea of what the statute required than what it actually says. Is that a problem?
Yeah, I think that the officer's idea of what the statute said makes sense if you assume the officer himself is always driving at the speed limit, or at or above, I guess, because when he approaches, then anyone who's driving in the left lane obstructing him then that would mean you're traveling below the speed limit. And if they're obstructing his flow of traffic, then I agree with you. I'm sorry, I see my time's expired. If I can, thank you. I agree with you that his explanation of the statute is not perfectly accurate. I think that regardless of whether I think he correctly identified a violation of the statute. I think that a mistake, what matters is whether an actual violation occurred, whether the stop was objectively reasonable, and I think that standard is met here. And I also think that the statute avoids being void for vagueness because it defines a condition where you have this duty when the normal flow of traffic is traveling slightly faster than you, and it prescribes what you should do. And the fact that you have to use some level of judgment to know if you have that duty in each individual situation, that's a feature that's present in a lot of our motor vehicle-related laws. We require people to kind of act reasonably with regard to determining if they have a duty to drive in a certain way. There's a lot of gradations and different speeds and different circumstances, and that doesn't make all of our motor vehicle regulations void for vagueness. So I tend to see no problem with this statute. Thank you.
Thank you as well, Counsel. Reply, Ms. Spellman?
I'd like to address the questioning relating to the itinerary or the travel plans going to and from where Mr. Salcedo was traveling from, how he was getting there, so on and so forth. Because the state and I have a clear disagreement about whether or not this is related to the mission of the stop, which is related to your license, registration, insurance, which are normal questions which relate to rules of the road and ensuring that a vehicle is traveling down the roads safely. The other factor of asking about travel plans or itinerary, which is the bulk of the questioning in which the deputy engages with Mr. Salcedo, I would assert is not relevant and is not within the scope of the original mission of the stop, which is the alleged traffic violation. And it's not related to that because...
Can I ask you about the timing issue again? Mr. Sloven read from the transcript where the deputy testified, at least he testified, that he saw the cell phones prior to going back into his cruiser with Mr. Salcedo. What is the basis for your claim that that's incorrect? And is there additional testimony or evidence that you would point us to that indicates maybe he didn't see it until he spoke with the passenger on the second time around?
If I may grab my transcript, which
Certainly.
is right on my desk. On page 18 of the transcript of the motion to suppress, the prosecutor for Johnson County asked, quote, "Did you observe anything when you were speaking with Mr. Rodriguez, the passenger? Did you observe anything in the vehicle that also caught your attention?" The deputy responds, "Yes." Question, "What was that?" Answer, "So I noticed that there was 3 phones in the vehicle with just 2 people." That's the first time when we realize that is the first time that he sees the cell phone. And then I do agree that there is some intermingling and some intermixing of talking about the luggage with the cell phones throughout the suppression hearing, but a close reading of the transcript of the motion to suppress supports that the 3 phones were not identified until after the deputy spoke with the passenger.
But what Mr. Sloven read was after that during cross, right, or probably redirect, right?
Correct. There are a couple other instances where they refer back to that. I would assert that the "and stuff" relates to the personal belongings. I don't think the "and stuff" refers to the 3 cell phones.
Okay, I have a question about, do you know of any legal authority that requires an officer to issue a citation or to process a citation if he has, and let's assume that he does have some reasonable suspicion for a bigger fish to fry, is there any requirement that he or she must process that initial pullover?
No, I don't think there is. As I was saying previously about the itinerary questions, I just want to mention that is important because that line of questioning does not relate to Mr. Salcedo's case regarding the mission of the stop, because when the deputy went to the window of Mr. Salcedo's vehicle right away at the onset of the traffic stop, he learned the true reason why Mr. Salcedo was proceeding at a slower speed in the left lane. It was because Mr. Salcedo believed, and the passenger believed, that they were in a construction zone because there was traffic speed limit zones with flags on the side of them. So what the state argues in their brief is that that question about itinerary relates to whether the driver might be tired. It might give the law enforcement officer some sort of idea on why they committed that traffic violation, but that's not the case here. The deputy already knew the reason why he allegedly committed the traffic violation. I want to be sure to make clear why we're asking that the court proceed under an investigative scope rule. And this was set forth in the Court of Appeals case, State versus Campbell, which tells us that doing an analysis under the investigative scope rule helps give law enforcement clear guidance on the scope of permissible conduct. It helps provide citizens with clear notice regarding the scope of their rights upon detention. It provides courts with a rule that can be applied consistently across the counties of Iowa and across jurisdictions.
Let me tell you what I think is the problem with the scope limitation is, I mean, what I see the Fourth Amendment and the Iowa Constitution both driving at is limiting the amount of time you're being held and limiting the seizure. And as long as the time is not being extended, how is it more of an inconvenience to me if they're asking some unrelated questions as opposed to just keeping quiet while they're processing that traffic violation? How is that a greater invasion of my right to privacy and right to personal integrity and so forth? That's the conceptual problem I have. Can you help me?
And I see my time is up, if I may respond. In this case, the deputy testified that his normal stops take a long time, and he testified that they take sometimes 10 to 20 to 25 minutes, which I think is an excessive amount of time for a traffic stop to process a mundane traffic violation. I think that when a deputy or a law enforcement officer has the ability to do a fishing expedition and do a criminal investigation within a traffic violation, really that is when a person's rights to privacy or a person's right under the Constitution to be free from additional questioning or asking for consent to search is a problem and is an issue. So when you get maybe a less efficient officer or an officer who has just gotten out of his drug interdiction training and wants to engage in these criminal investigations during these normal traffic stops, it's a problem for the citizens of Iowa. Thank you for your time.
Ms. Spellman, thank you as well. Mr. Sloven, thank you again. The case of State versus Salcedo is now then submitted, And before hearing the next case, we'll sit in a brief recess to allow the students from Madrid to leave the courtroom for the tour that's planned for you. So thank you again for being here.